Thank you very much, Corey. Good afternoon, everybody. I would like to start my presentation by thanking all the organizers, the IPO, my colleagues from DigiTrade, and IPKey, Southeast Asia, Thiago, also you, Corey, and all persons who have contributed in the organization of the event, including Erica, Georgie, Ruben, all the technicians. It's a great pleasure for me to have the opportunity to present the recent development in the IP Action Plan. Next slide, please. In November 2020, the Commission published an action plan on intellectual property. It is designed to address specific IP challenges like fragmentation. For instance, the result of fragmentation is that patenting in the EU is 10 times more expensive than in the USA. Also, counterfeiting. In 2016, up to 6.8% of EU imports were fake goods. These fake goods caused direct sales loss and approximately 416,000 direct job losses. This is an average figure for the period 2013-2017. This leads not only to unemployment, but also to health-related issues for our citizens. For instance, when you use counterfeit masks. Another challenge, of course, is the COVID-19 pandemic and all the economic consequences. The IP Action Plan need to support the EU recovery and resilience. After the COVID-19 pandemic, the EU economy is rebounding from the recession faster than expected. Order books are full. However, the growth momentum is facing new headwinds. Energy prices, in particular for natural gas, have increased, and these prices are now well above the pre-pandemic levels. There is also a shortage of components, in particular electronic components like semiconductors. EU companies, as highlighted by the two speakers, Agatha and Sandris, EU company, in particular SMEs, need to take care of their intangible assets. IP is a key driver for economic growth and help companies to valorize these assets. The IP Action Plan aims at enabling European creative and innovative industry to remain a global leader, and it also helps speeding up Europe's green and digital transition. The IP Action Plan has set out key steps, first to improve protection of IP, for instance, support the rollout of the unitary patent system or modernize the EU legislation on designs, also strengthen the protection system for geographical indications. Other goal of the IP Action Plan is to boost the uptake of IP by SMEs. As already said, SMEs, only 9% of EU SMEs have registered IP rights, while SMEs that own IP rights generate up to 78% higher revenue per employee than SMEs that do not. So it's very important to help SMEs. Another key aspect of the IP Action Plan is to facilitate the sharing of IP. It is important to have IP to protect innovation, but it's important to share it, to encourage also innovation. And in this respect, it is important to organize licensing, encourage licensing, and promote data access and sharing in general. Another very important point of the IP Action Plan is, of course, to fight counterfeiting and improve the enforcement of IP rights, for instance, by establishing an EU toolbox against counterfeiting. And in general, the IP Action Plan is here to set global standards. You know that in the EU, the global standards are very high. So it is important that we have these standards. EU is recognized for this standard. It's important that we can set them up. The focus of the IP Action Plan has, however, to be balanced. We have to make sure that competition remains, competitiveness first. The IP Action Plan and IP tool have to remain business strategy. We do not want to have companies barricade themselves with IP. It is important that IP is here just to improve management, to show that there are different IP protection methods, and not protecting the intellectual assets can also be an option. And we also want to have the IP not being standalone. It's important that IP protection is balanced against business innovation and innovation support. We do not want again that companies barricade themselves with IP and block innovation. So IP should go together with innovation support. I must confess that even if the focus of this event is trademark and design, there are major steps in the development of the IP action plan that I need to highlight. It is also very important regarding the recovery aspect. I want to speak about the unitary patent. So I will speak a bit about the unitary patent system. I think it's very important because we have very recent development which allow us to tell you that the new system may be expected to be launched in late 2022 or 2023. This is a very, very important aspect. We've been waiting for the unitary patent system in Europe for a while now, and this is thanks to development. First, the German Constitutional Court has recently dismissed remaining challenge to the ratification by Germany of the United Patent Court Agreement. And more recently, Austria ratified this Patent Court Agreement. And this started the period for a provisional application of this agreement. It started very recently on the 19th of January. So this is a very interesting improvement, and I wanted to highlight this. The unitary patent will be a legal title that will provide uniform protection across all participating countries. It will give a one-stop shop basis, like a bit like the trademark, and the Unified Patent Court will offer in parallel a single specialized patent jurisdiction. We are expecting huge benefits. It will provide huge cost advantages and reduce administrative burdens in Europe. It will make the existing European patent system simpler and less expensive. It is very important for inventors. It will also end complex validation requirements and, for instance, limit drastically expensive translation requirements in all the participating countries. And it will, in general, make the EU more attractive. This is very important in supporting innovative SMEs, in particular in the pharmaceutical sectors. These SMEs have fewer resources to embark on lengthy development cycles. So it's the European patent will help them. This is also true for the supplementary protection certificates. I will call it SPCs. It's easier for me. The SPCs, it's an IP right that would serve as an extension, that actually serves as an extension to a patent right. They apply to specific pharmaceutical and plant protection products, and it is a way to counterbalance for the years spent in research. There was an evaluation of the SPC legislation in Europe. It has been published jointly with the IP Action Plan, and the Commission is considering now improving this SPC system, and we could expect in the future some changes that could be either non-legislative, like guidelines, or legislative intervention, like, for instance, it could be the creation of a unitary SPC title, like a patent title. It could be also the introduction of a unified procedure to grant the current national SPC title. And the Commission is going to publish this year a call for evidence to get feedback from stakeholders in this area. The challenge of pandemic, it is very important to highlight the importance of licensing the aspect of patents. In this area, we have the standard essential patents, also called SEPs. These patents protect technology that underpin the value chains of the future, like in connected cars or smartphones or 5G. They are an important incentive for companies to put their technology at the service of standards. A company create a patent that becomes a standard. So we have to incite this company to share these standards standards. And also this result in allowing the standards to be used as widely as possible. And as I told already, standards in Europe are very high. So it's interesting to have them expanded. As a follow-up to the IP action plan, the Commission would like to bring more transparency, efficiency, and predictability in SEPS licensing. An evaluation was published in 2020. It highlighted some weaknesses like fragmentation, administrative burden, especially for SMEs applicants. This leads also to legal uncertainty. For instance, the scope of protection can differ across the EU. It's very difficult for SPC users and generic makers. There is also a lack of transparency in the SPC area. It is difficult to trace what SPC protection exists for which products in which member states. So the Commission will publish very soon, mid-February. This date is to be confirmed. Also, call for evidence to get stakeholder feedback. Public consultation will be open, so probably until mid-May. The objective of the Commission is to achieve a balanced package of measures that would promote solution for the industry, so to allow licensing, but also to preserve IP. I must also address another issue which is important in the area of sharing innovation. It's particularly linked to the COVID-19 crisis. It is a compulsory licensing system adapted to crisis that the EU would like to put forward. The COVID-19 pandemic has created debates about the need for IP tools to ensure access to critical technologies, in particular to access to vaccines. The TRIPS agreement provide already for some possibilities of using compulsory licensing. In Europe, the Commission thinks that voluntary licensing should always be a plan A. However, we cannot avoid a plan B, especially in emergency situation like a COVID-19 crisis. So the Commission is currently would like to act on IP in this regard, propose to set up an efficient, coordinated and adapted compulsory licensing system to crisis of European scope. And now I will come to the core interest of this event. With the IP action plan announced a design reform. In fact, we had two old existing designs legislation. They date back to 1998 or 2001, and evaluation that we ran in November 2020, revealed that the design legislation is still broadly fit for purpose. As a matter of fact, design legislation in Europe led to fewer delays in design registration and lowered the costs, but there are a number of shortcomings. For instance, design protection system in the EU might be underused. In fact, there is due to a lack of awareness. There are also heavy representation requirements, heavy conditions for filing multiple applications. The fixed structure is very complex too, and there are also a lot of uncertainties. For instance, we don't know whether it's possible to protect graphical user interfaces or icons as designs, as an applicant, of course. There are also uncertainties, possibility to file not only static, but also dynamic views of designs. Also, in relation to 3D printing, the scope of the private use limitation is unclear. So all these shortcomings need to be addressed. A very important aspect also is the issue of design protection for repair spare parts. It is the most controversial. A public consultation that was run last year confirmed these findings. The Commission, as a result of all these steps in the design protection area, is working on two legal drafts. They are scheduled for adoption in the second quarter of 2022. The reform in general aims at improving accessibility to the to registered EU design protection through, in particular, a simplification of procedure, for instance, modernizing requirement for design representation to allow, for instance, video files, facilitating also the filing of multiple applications, and this without being restricted to the same Locarno product class, and also lowering the fees, and this to the benefit of SMEs and designers. Another aim of revision of the design's legislative framework in Europe is to enhance interoperability between EU and national design system, in particular through harmonizing procedural rules. The last aim is to open up the spare part aftermarket for competition. This is for the design reform. And I will now go on to also a very important aspect of the IP action plan. It's the geographical indication protection. Protection that exists currently in Europe at European level is concentrated on agricultural product and foodstuff. At EU level, there is no protection for other products that we called craft and industrial products. The IP action plan announced that first that it would modernize the protection that is currently offered at EU level for agricultural products, but also create a system for craft and industrial products. There is a broad support for this idea. Since 2015, the European Parliament has repeatedly called the Commission to launch a legislative proposal to protect craft and industrial products. And there is also a strong support from a majority of member states, despite certain reluctance by a minority of member states. Many stakeholders have called the Commission to create a regulatory framework, and there is also a very important event, the EU accession to the Geneva Act of the Lisbon Agreement. This agreement deals with appellation of origin and geographical indication. This EU accession in November 2019 has highlighted that it's very important that the EU provide at EU level protection not only to agricultural products but also to craft and industrial products. As a result of a public consultation that was conducted between April and July 21, a vast majority of respondents saw the need for an EU-wide initiative. 68 of the respondents expressed strong support for establishing a new protection system for craft and industrial products in the form of a sui generis GI protection. This is the protection that already exists in the agriculture area. Some opponents consider that the trademark system is sufficient, and we have run an impact assessment, and the Commission is now drafting a legislative proposal, and we expect adoption for this spring. And I would like to finish quickly, because I see that the time is running, with IP enforcement. Fight against counterfeiting also is very important and mentioned in the IP action plan. With the coronavirus, it showed that there is a new trend in counterfeit medical items. Despite efforts to battle counterfeit goods, the market is still striving, with, for instance, an increase of detained articles at EU borders. And there is, in particular, a surge of goods related to COVID-19 that are counterfeited, like face masks, other protective equipment, and even vaccines, which is really a high problem. So the Commission is developing an EU toolbox against counterfeiting. This is part of the EU strategy to tackle organized crime. And basically it aims at defining coordination to combat counterfeiting, both online and offline. For example, by strengthening cooperation and information sharing between right holders. And we do this together with the EU IPO. We opened last September a dialogue with stakeholders based in particular on call for evidence, and this call has just been published, a series of targeted workshops. Now I covered broadly the main point of the IP action plan, and I will give the floor back to our chairperson. Thank you very much.
Thank you very much, Valerie, for the comprehensive presentation. Just one question on the action plan. Is there any trademark related initiative in the action plan?
Well, this is, of course, a very good question. Trademark has quite recently been modernized, and so it was not one of the main focus of the IP action plan. But for instance, in the counterfeiting area, we are addressing also trademark. Trademark are highly counterfeited. It is not one key focus, but it is still ready. We have recently had a study to see how the last trademark directive has been implemented in the member states, and we because the last date for implementation was February 2019, and the study went positive, showing that there was a good implementation. And also, as I said, it's not the main focus, but we have this still. IP cannot live without trademarks, of course, trademark protection, of course.
Thank you very much, Valerie.